Hello everyone and welcome to Legally Speaking. Let me introduce myself. As most of you know me, my name's Rosa Raco from WR Law, and this is Fleur Jackson.
Hi everybody.
Fleur is the principal lawyer at Fortitude Legal here in Bendigo. They're a boutique law firm. I think they won Boutique Law Firm of the Year last year, didn't you?
Yes, that's right.
Yes. And they operate out of Geelong, Ballarat and Maryborough, is that right?
Yeah, that's right.
Yes.
Yeah.
So Fleur works with me often on matters, and we collaborate on matters. That's when I'm doing employee matters. As you might know, I do employee and employer matters. So I'm going to share the screen now and start the presentation. I'm not very good at this, as you probably gathered, but if you go to the chat and if you want to ask any questions, I can see the questions and either answer them then or take a note for them later. So share screen. No, that's not working.
Yeah, it is.
Oh, it is working? Oh, good. Let me go back. Sorry, guys, I'm just getting used to all this. Okay, so we're going to talk today about unfair dismissal and about workplace injuries. First of all, what I want to talk about this every time I do a seminar, because I think that people I had strange questions from a client yesterday about why do I need to pay someone why does a modern award need to be included in their employment contract? Why can't we just use the NES? And I had to do a sort of an employment 101, and this is the CEO of a company. So, you know, it just surprises me how little people really do know about employment law at times, but that's all right. It's my baby, not everyone's baby, so that's all right. So I like to do this image because I think it explains it quite well, and I hope it does. So the blue is supposed to represent like a big sea of common law, and that all our law sits in a sea of common law. And sitting in that sea is legislation. First of all, it's the Fair Work Act. So that is our foundational piece of legislation. And then above that are modern awards and enterprise agreements. So the Fair Work Act will cover what your absolute base entitlements are, but modern awards and enterprise agreements go into more particularity about what you get at your job. So say you are a shift worker, it'll talk about your shift allowance, or it will talk about meal breaks. And it can either be an award which covers an industry like nurses, or it can be an enterprise agreement which covers an enterprise. And there's movement back and forth between those two. But I think, and some of you who've been in this space a long time might, comment, but I think there's been a swing back to modern awards in recent times because they've become simpler and more just easier to access. Years gone by, showing my age, they were very, very complicated documents, and there were hundreds and hundreds and hundreds of them. But there was a movement X number of years ago, now maybe 10 years ago now, to modernise them and bring them into the modern age. That's why they're called modern awards. So a lot of awards were amalgamated and they were simplified and made much more accessible to people. Sitting on top of modern awards then are employment contracts and policies. So employment contracts and firstly employment contracts, they again talk about things that your modern award wouldn't talk about. So it would talk about things like if we give you a laptop, when you leave, you need to give it back to us. Or if you've got access to client files information, you're not allowed to keep that access and you're not allowed to take it off the workplace. And then there's policies. Policies are perhaps a bit more about how you behave at work. Although some policies I see as being absolutely mandatory, like an OC health and safe policy, an anti-bullying policy. So they actually protect employers and protect employees from bad conduct in the workplace. I can talk about all of these things in more detail if anyone's got any questions. But the important thing to realise that is also going on is, firstly, each one of those gives you more and more. So you can't contract out of your base entitlements under the National Employment Standards or under the Fair Work Act. So you can't get less. There's something called the Better Off Overall test. So whatever you get, you've got to be better off overall for getting it. The important thing to remember as well is that this isn't the only legislation. All of you would have heard, I'm sure, of discrimination law or occupational health and safety law. So they impact in on all of these things. Again, it can get quite complicated, which is perhaps part of the reason I like employment law, because it is complicated and interesting. So, for example, I'll give you an example. If you're sick, I'm talking to employees now, if you're sick at work, if you're sick and you're not at work, forget work cover for a moment. But if you're sick and not at work, and you've used all of your entitlements, so you've used all your sick leave, all your long service leave, all your annual leave, and you're effectively on 3 months, 3 months has passed, and you've been on unpaid leave for all that time, under the Fair Work Act, your employer can dismiss you, because there's a rule or a regulation that says if you are not at work for 3 months without any pay, you can be dismissed. But what happens then is if you're sick, and the reason you're not at work is because you're sick, the discrimination legislation kicks in. It says you can't sack me because you need to make reasonable adjustments to let me come back to work. And there's a whole lot of case law around what reasonable is, and that goes to how big the organisation is. So what's reasonable for University of Melbourne mightn't be reasonable for the local tyre fitting company. So there's a whole lot of stuff around there. But it's not as simple as going, okay, you're 3 months out of work so you can be sacked. There's a whole lot of other things coming in. And then I said don't think about work cover, but maybe you are sick because you were injured at work. Fleur will talk about this, because you either have a psychological injury or you've fallen over and broken bones and you can't work. Then you've got the health and safety legislation coming into place and work cover coming into force. So it's quite complicated, and this is why I like to try and talk to people about it, because the more people understand, then the more easy it is for them to understand what's going on at work for them, and to stand up when they think things aren't going the way they should. Let me go to the next slide. I'm talking today about unfair dismissal. I know he's the man of the moment with the presidency at the moment, but before he was the president, he used to have that show, was it The Apprentice or something along those lines, where he used to fire everybody all the time. We'd like to fire him. Well, I'd like to fire him, and I've got lots of Italian American cousins who'd certainly like to fire him, but anyway, that's for another day. Unfair dismissal has got a number of components. Firstly, there must be a valid reason, and a valid reason needs to be because of conduct or performance. There's another reason, and that could be redundancy, but I'll talk about that in a moment. That's when the business needs to change its operations. And the dismissal cannot be harsh, unjust, or unreasonable. And there's a lot of case law around that. Well, I'll just make sure my phone is off. I thought I turned it off, but I haven't. I'll talk about that. Christine, can you just grab my phone? So we'll talk about that now. Let's go to the next one. When it looks like you're going to be dismissed, or you suspect you're going to be dismissed, these are the sorts of things that need to be covered off by your employer. You need to know the reason for the dismissal before you're dismissed. So they just can't call you in and say you're sacked. I've had cases where people have been texted and said you're sacked. You've got to know, what did I do? Was it a performance issue? Was it a conduct issue? This is important as well. You've got to have a chance to respond to that reason. I mean, there's a famous case I talk about often, and maybe people who tune into this get sick of me, but there was a case where some fellow, it was in country Victoria, there was a big write-up in the paper how he'd been charged with, I think it was either child sex abuse or rape or something pretty unpleasant, and his employer just sacked him. And it was actually held to be an unfair dismissal because he didn't ever have a chance to, he hadn't been found guilty, that's a whole other matter, but they never gave him a chance to respond. They just read the newspaper article and sacked him. I mean, what they should have done is called him in and said, we've read this newspaper article, and depending on what the business was as well, like if he was working with children, for example, you know, that could be something, again, we've read this article, what is your response to what's being said here? They've got to consider that response and then come to a decision. So these are important things for you to remember if it looks like you're going to be sacked. There's not an automatic right to bring a support person, as in, there's not an automatic right to have a support person, but what the right is that your employer cannot prevent you from bringing a support person within reason. So if someone says to you, we're going to have a meeting and we're going to talk about your really crap performance at work, you can say that they don't have to offer you a support person, but you can say, I'd like to bring a support person to that meeting. Now, a support person is just that, a support person. Usually, unless it's allowed for in your enterprise agreement, they can't speak for you or advocate for you. What they can do is take notes, be there as a witness, and actually be a support person for you. If they're saying they're sacking you for performance-related reasons, one of the key things with this is, were you given the chance to improve your performance? You may have heard the term performance improvement plan. If they say to you, your performance is really crap, and this is the reasons it's crap, they've got to sort of say, you were supposed to deliver a document last week and I still haven't got the document. You know, they've got to document, for want of the alliteration, they've got to tell you why your performance is bad, and then they've got to give you a chance to improve. So they put you on something that's called a performance improvement plan. It doesn't have to be War and Peace. It's just a simple, like, you might meet with your manager weekly, fortnightly, depending. And in that fortnight, you'll have tasks related to your poor performance that you need to show improvement on. If you don't show improvement on, then that could be then valid reason to dismiss you. So there's also any other factors that the Fair Work Commission considers relevant, and these are all quite interesting, actually. It can go to your age. If you're very old and you're very young, that might be something that they think about in terms of, was it a harsh decision to sack you? This is all about harshness as well. So we talk about the harshness now. I hope I've got that as the heading. Yeah, when my dismissal will be harsh, unjust and unreasonable. So these are the base reasons. But the Commission's a very powerful body, and it can go, well, I'm going to think about a lot of things here. You know, are you very old? Are you unlikely ever to get another job? Are you very young and it was inexperienced, they didn't give a chance to train you? Have you been there for 40 years without any faults, without any conduct issues or performance issues, and now suddenly you've had one issue and they're sacking you? What your qualifications are and the ability to find employment following termination. This is perhaps particularly relevant during COVID, particularly in Victoria. How easy is it going to be to find another job? And they might ask the employer to reinstate you rather than to sack you. Again, they'll look at things like, do you have a lot of kids that you're supporting? Do you have lots of assets that you can draw on? Do you have lots of debts? Do you have really poor literacy levels? Is it really going to be hard for you out there? Let's talk about, they're the sorts of things that if you look like you're going to be made, you're going to be dismissed, you want to make sure, let me go back to the previous slide, that all of these things, and I could put this up on my website, certainly at least this slide for people if they want to have a look. Do you know the reason? You must have a chance to respond. You must be permitted to bring a support person if you ask for one, and you must be given the chance to improve if it's performance related. If it's conduct related, you know, what is the conduct? If you caught swearing at work or really badly swearing, and they say that's reason to sack you, does everyone swear? Is it a culture? Is it a workshop where everyone gets around and swears all the time? And so sacking you over swearing is not going to be reasonable. It's going to be harsh. There might be another reason underlying it. So bear all these things in mind. Let's look at redundancy. So you can make someone redundant. I've written that in complicated legal speak. But basically what I'm saying is, if the redundancy is genuine, then that's a defence to an unfair dismissal claim. So what that means is you can be dismissed if the business needs to make you redundant, but the redundancy has to be genuine. And there's been a lot of cases lately, and I'll talk about a couple, that the redundancy hasn't been genuine. They've just seized on the opportunity to get rid of people during COVID and haven't done it properly, haven't done it with consultation, and it actually just is really, they just want to get rid of this person. So for it to be genuine, the position is no longer required to be done because of an operational change. So it may be that, well, let's say during COVID, keep JobKeeper out of this, but during COVID, you know, they don't need to have an assistant manager and a manager position because there's just not that much going on in the business. So they decide to cut the admin manager position. So they don't need that job to be done by anyone. But what they can do is split up that job and give it to everyone else. So if the manager's really, his workload is decreased as well, then he can take on the admin manager's role and make the admin manager, the assistant manager, redundant. If the business is a big business, or if they've got lots of branches or lots of associated entities, so businesses that, like say, a business might have 10 different fingers into 10 different pies around Bendigo, is it reasonable to redeploy you to somewhere else in the business? So say it's a receptionist position and let's give this example. Say it's a receptionist position in a beauty salon. Well, now with code 3, whatever it is, level 3 restrictions, beauty salons, my understanding is, can't operate. So you don't need a receptionist. If you can't operate, you've got to close. But if you've got 2 other hairdressing salons that can still operate, and you might be able to redeploy that receptionist to that position, to another position in another business that's still operating. So it's got to be reasonable. And a key thing here is, well, I talk about this a lot, is it's not the employer to decide what's reasonable or not in this situation. It's the employee within reason. So again, the famous case I talk about here a lot, because it's easy for me to remember, is the Jenny Craig case. This was many years ago now, where this woman was the manager of a Jenny Craig outlet, and they didn't need the manager position anymore, but there was a vacant position as a consultant. Now, this manager would have taken that vacant position, but it was never offered to her because the employer decided that she would want it. Well, she did want it because she'd rather that than be unemployed. So that was held to be an unfair dismissal. The point to remember is it's got to be a vacant position. They don't have to create a position for you, unlike health and safety law, what Fleur will talk about when you're injured at work and that you're doing suitable alternative duties. There's an obligation to create work for you. There's no obligation to create work here. You've got to be consulted with. So this is if you're covered by a modern award, my abbreviation, or an enterprise agreement. And I don't know if I've got the consultation requirements here. Let me have a look. No, I haven't. But usually what that means, and they look onerous, but really it's just about coming to you and saying, we're thinking of making your position redundant because we've lost 10 clients in the last month and we can't run the business anymore. And then it says, we've thought of everything. We've thought of redeployment. We've thought of part-time. We've thought of whatever, standing you down without pay, but none of that is going to work. So we're thinking of making you redundant. Then they've got to give you the chance to say, well, actually, I was thinking of going overseas for 6 months. So what if I take 6 months leave without pay and not be made redundant? Can I keep my job and have a job to come back to? So it's just got to give you a chance to come up with ideas so that you're not redundant. And there's been a number of cases that they've failed on the consultation. It's been really interesting. It's almost every case has failed on the consultation that I've read in recent times. And if it fails on the consultation, then the commission will find it's an unfair dismissal. I've got a case here I'll talk about. I'm going to talk about this in a minute, the Great Horse Theft case, because that's my case and I'm very proud of it because it was a very difficult case. But this one's a failure to consult. And again, you can have this case. I talked about this last week in the session I do for employers. This young woman was made redundant just days before the unveiling of JobKeeper. The Fair Work Commission held that the employer didn't consult with the obligations under the clerical ward. She was covered by the clerical ward. And they found that if they had engaged in that consultation process, she would have been employed long enough to have got JobKeeper. What they said was that they met with her and they said, you're going to be better off financially if you apply for job, I think it's Keeper, maybe Seeker, if you apply for Job Seeker. And they said, have you got any questions, comments or suggestions? She didn't. She said the tribunal should have accepted reduced hours if they'd offered them to her. She didn't want to lose her job, but they didn't offer it to her. And Deputy President of the Fair Work Commission said, simply asking employees if they've got any questions or comments is not consultation. That's basically saying they had pretty much decided that she was redundant and the consultation was hollow. It was like, we're going to make you redundant, have you got any questions? No, and so you sort of scurried out the door. They failed to discuss measures to avoid or reduce the adverse effects of the change on employees. So they didn't talk about what measures they could implement to avoid being made redundant. That was like another case I talk about a lot in this space, and that's the Ausscript case. I'll talk about it. I haven't got a link to it here, but that again was really strong on the consultation. And Ausscript is a service that does typing at the court system during court cases. And when COVID hit, no one could go to court. So all these people didn't have any work to do. They couldn't type anything because there was no court cases going on. The courts were shut. So they just made everyone redundant. But again, it was one of the first cases, and the Fair Work Commission found that well, hang on a minute, you didn't actually talk to them about other options. You didn't say, you know, COVID's not going to last forever, take some leave without pay, go off and do something else. Training is something that can be considered. And again, it was found to be unfair dismissal. In this case, it was found to be an unfair dismissal. And it was really just around these sorts of things. They told her she'd be better off financially. They told her, or really asked her, but it didn't really seem to be a question, you know, have you got any comments or suggestions? And that's a point to remember. If your employer on the spot says, have you got any comments or suggestions? Well, no, you haven't. Well, great, see you later. That's not consultation. They're supposed to say, have you got any comments or suggestions? I'm going to give you a couple of days to think about it and to come back to me with an alternative proposal. That's true consideration. Then they're supposed to take some time, not just immediately say, oh, well, thanks for that suggestion. No, we're not following it. They're supposed to go away and consider what you've said and come back and see whether it's feasible or not. So it's a bit of a process. Let's talk about the great horse theft case. Let me go back to that. This is an unfair dismissal. This is for a different reason, though. This is a case that a young girl came to me, a lovely young woman, young girl. She's in her 20s, which is young to me these days. And she was a farm manager of a farm outside of Lansfield. Everything was going swimmingly. She'd been there for a couple of years. She'd been promoted to a manager from a rider position. But in February this year, her employer approached her and gave her a revised contract. The contract reduced her hours, it changed her conditions of employment, and it changed her reporting lines. So she no longer reported to the owner. She had to go through someone else. Now, that is called, in legal speak, a unilateral variation of a contract. That means one person has varied the contract without consent. And if the variation is significant enough, and in this case, I felt it was, and ultimately so did the Commissioner, it could be the same as sacking you. So if you're in a job and you're earning $80, or you wouldn't be earning $80 because you wouldn't be under an award. Say you're earning $30 an hour under an award, and your contract then comes back and says, we're changing your job and you're going to be earning $15 now, which would be the case because that's under minimum wage. And we're going to change your job from managing the store to stacking shelves out back and all these. Well, that's changing your fundamental contract of employment without your consent. So we filed an unfair dismissal claim. It was a long, arduous battle because they fought long and hard against us. We went to one conciliation, we went to a second conciliation. They made all sorts of assertions that it was a mistake, they fixed the mistake, they didn't mean to do it, but pretty much they did it straight away. And the way the horse came into it was that really all my client wanted was this horse. This horse, she was training horses, and this horse was a thoroughbred horse and it had broken down. So the vet bills were quite exorbitant, and the owner, the respondent, the employer said, I don't want to pay these vet bills anymore, you take the horse. Which Isabel was delighted because she'd formed a strong attachment to this horse. Because it was all done through some governing body, you know, they showed these horses professionally, the horse had to be registered as the transfer ownership. It's not like, you know, here's a horse, go away. She couldn't show the horse unless it was legally in her name. So they drew up a contract with a $1 transfer fee to make the transfer legal so it could get registered with the governing body. Once Isabel challenged the downgrading of her contract and the downgrading of her position from farm manager back to rider, bear in mind she had no performance issues, she had no, there was no issues. It was just some sort of decision the owner had come to, and we don't really know why, except that this was perhaps a course of conduct she'd done before. She revoked her decision, she revoked her agreement to transfer the horse, and she reported her to the police as stealing the horse. She threatened to come and have sheriffs raid the house. It was all quite terrible. So really all she really ever wanted was the horse. But I said, look, I'm an employment lawyer, so I can run an unfair dismissal for you, and let's see if we can get the horse in the mix somehow. But ultimately, we couldn't get the horse in the mix, and that's sort of a bit funny in the end. I tried to get it in the mix, and my barrister rang me, who was helping me, and said, please don't put the horse in the compensation, because the Fair Work Commission doesn't have jurisdiction over horses, it said, so I had to take it out. But we went, and ultimately we had a hearing before Commissioner Sarah McKinnon, and she found that it was an unfair dismissal. She rejected the evidence. She rejected all the evidence pretty much of the employer and said that they had unilaterally changed her contract. They had demoted her, and that this was reason to say that it was an unfair dismissal. They actually advertised her job. They sacked her, I think, on the... Oh, she resigned in the end. When they changed her contract, she resigned, which meant that she didn't accept the contract variation. So that's what you would do in that situation, not before you talk to me, but that's what you would do if they changed a contract like that in such a significant way. And they advertised her job straight away. So, the farm manager's job. So they said they didn't need the farm manager's job anymore, but then they advertised it the following week. So there's a whole lot of evidence we had to gather. And just this week, I've put submissions forward for compensation. So unlike a conciliation where you sort of work out what the compensation is on the day, this had to be submissions. This is where I put in the horse and my barrister asked me to remove it. So I'll go back to the end. Thank you for your attention on my part. My mantra in employment law is get advice early. If in doubt about what's going on, don't quit, don't storm out, don't do anything. Come and get advice. I think a little bit of money spent up front can save you a whole lot of grief down the track. It can help you perhaps negotiate an exit rather than be sacked. At the moment, I'm negotiating an exit for someone who's, I think, being railroaded out of his business, out of his company. He's been there 8 years and he's being railroaded out. And I'm trying to negotiate an exit. And what that can mean is that I can then negotiate maybe a good payment for you, maybe a reference for you, maybe some EAP, Employee Assistance Program, or even a career transition thing for you. So just, I think, speak often, come up, give me a call, and we can talk about what we can do, and I'll be very honest what I can't do. So now I'm going to hand over. Has anyone got any questions before I do hand over? There's no one sort of saying there's any questions. You can have a question and answer at the end. But if there's any questions. Thank you, everyone. Is there any questions anyone has? I finally worked out how to use the question thing and no one's got any questions. It's quite...
Oh, no.
But you can always come to us later with questions if you have. Oh, Kathleen, someone's raised their hand. That's something new for me, raising their hand. Oh, here you go, Kath, you can talk. There you go. I can allow you to talk.
Thank you. Rosa, it's Kate.
Hi, Kate. How are you?
Well, thank you. And I just wanted to reflect on your earlier comments around the legislation, and it is different because we have 3 states that we work across in workers' comp. So obviously we have different insurers in those states. But I also want to comment on that the inherent requirements of the current role is critical. So even if someone put in that they had required injury from another employer or non-compensable injury, it's not related to the ability to perform the inherent requirements of the current role, then you really can't consider that as a reason not to recruit that person.
Speak up a bit. You can't consider that what?
You can't consider that as a reason to cull or not to appoint that person into...
Yeah, that's right. Yeah, that's all right. That's my understanding. I haven't looked at it for a long time, but that was my understanding as well. Was there anything you learned today, Kate?
Probably not. Probably not, because at the moment I'm also managing the workers' comp section, and that's always been part of my brief in other companies. But it's really good to be reminded to be on track. And I like Fleur's approach is that this advice should be available to employees as well, because I think a good employee who is doing the right thing should have no fear of a claim. So enabling our employees, as we're required to do under law regardless, I think is a really positive and value-adding expression to our employees.
Great, fabulous. Does anyone else have any questions or comments? Is there anything that people would like us to talk about going forward? I was trying to do a poll, but I think I mucked that up. If there's anything anyone would like us to talk about going forward, then by all means, please either write to us, tell us now. Fleur's got a wealth of experience across the whole personal injury sort of sphere. So she can talk about transport accidents, or we can talk, Fleur, what can you talk about?
Oh, you know, being injured, you know, walking down the street, whatever. If you're injured in Victoria.
Fleur's your girl. If you're injured, Fleur's your girl.
Yes.
If you're being sacked, I'm your girl. So come to us. All right, everybody. Thank you so much for coming. It's been a real delight to do this today. We're going to do it probably bi-monthly, and we'll advertise it widely. And if you've got anything you'd ever want to talk to us about, please feel free to give us a call. Thank you.